Hi, my name is Dan Stone. I'm an attorney in the Elder Law Trust and Estate Department at Mandelbaum Barrett. And today I'm going to be talking about the unfortunate passing of Liam Payne from the band One Direction. As many of you may or may not know, Liam passed away in 2024, and he died without a will. And as a result of that, pursuant to the laws of intestacy in the United Kingdom, his entire estate passed to his 9-year-old son, an estate valued at approximately £24 million. And despite the fact that he shared a close relationship with Bear, the child's mother, her name was Cheryl, because they were unmarried, Cheryl was not entitled to any portion of his estate. If that same situation occurred here in New Jersey, the results would be very similar. In New Jersey, if you die without a will, but you're married, your spouse will share in your estate in differing proportions depending on whether or not you have surviving children or parents. Like in Liam's case, if you die with children but you're unmarried, your estate will pass to your surviving children. If you're unmarried and have no children here in New Jersey, your estate will pass to your surviving parents. If you have no parents, then to your siblings. If no siblings, then to your aunts and uncles. And if no aunts or uncles, then ultimately to the state. As we saw in Liam's case, unmarried partners, no matter how close they may be to the decedent, are not entitled to any portion of the decedent's estate if they died without a will. Here in New Jersey, if as a result inheritance vests in a child under the age of 18, their inheritance is held in what's called the surrogate's intermingled trust fund until that child reaches age 18. The parent, each and every time they want to make a distribution of that inheritance to the child, has to obtain court permission, which can be costly and take a lot of time. Separately, as soon as the child turns age 18, that inheritance is released to them, regardless of whether or not they're ready to responsibly manage that inheritance. This situation could have been avoided had Liam been more proactive in his estate planning. Had Liam created a will, he could have specifically left funds for Cheryl, the mother of Bear. He could have established a trust for Bear to ensure that if he received inheritance, it would only be at ages that he deemed were appropriate for him to manage those funds. And he could have appointed a trustee to oversee those distributions until the age that Liam thought was appropriate. For blended families, the lack of a will can create unintended consequences. It's important to be proactive so that you can ensure that your estate plan conforms with your particular family structure. If you have questions about estate planning, our team at Mandelbaum Barrett is here to help. Please do not hesitate to call. Thank you very much for listening.